You don't have to look it now, but. The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. We have 3 cases on our docket this morning. We may not take a break, but we may. So, plan accordingly. The first case on our docket is 25-5026, U.S. versus McCarthy. Mr. Duncombe.
Good morning, Your Honors. May it please the Court. I'm going to endeavor this morning to reserve about 2 minutes of time for rebuttal, although I understand it's on me to actually follow through on that. Let's see how close I actually get. This is a case where the court should reverse the judgment of the district court because under any canon of construction, the precursor statutes apply to the McCarthy's conduct. And because the precursor statutes are not vague as applied to that conduct. The McCarthys knew that their customers were using their product to make and prepare drugs, even though some other people might have used those same products to make and prepare poppy seed muffins. This is a statute, the precursor provisions, with two lists that serve two distinct purposes. But even if the second list, the more general list, is limited or informed by the first list, the McCarthy's conduct still fits comfortably within the second list. The McCarthys have ultimately proposed no coherent dividing line that excludes poppy seeds from the provisions of the Precursor Act. But wherever the line is between conduct that could not violate the precursor statutes and conduct that could violate the precursor statutes, the McCarthy's conduct is comfortably on the illegal side of things.
The statute's a bit of a trap, isn't it? I mean, it expressly excludes unprocessed poppy seeds. And then,
We disagree, obviously, but
then there's like this secret trapdoor that if you don't keep reading, drops according to your interpretation.
we don't think it's secret at all. And the first thing that I'll point out is the McCarthy's argument is essentially the same argument that failed in Cassir, which is that because the statute named cathinone but didn't name cat, that somehow lulled defendants into a false sense of security. That, well, I don't know anything about cathinone and all I have is cat, so it must be legal. However, Cassir is distinguishable because cat and cathinone would have been in the same section of the Controlled Substances Act where it defines controlled substances. And so Judge Holshue's argument, if you find that persuasive, which the other two judges on the Sixth Circuit didn't, was that that list in the same section of the statute was narrow and precise, and now the court was trying to expand it by including cat. Here, the statute at issue is the precursor provisions, and that statute is broad and expansive. And the McCarthys are trying to say, well, if you close one eye and squint, and you look at one portion of a different part of the Controlled Substances Act, that excludes poppy seeds. And we know that excluding something from one or two definitions in Section 802 doesn't mean what the McCarthys say it means. It doesn't mean that that thing is excluded from the CSA altogether or that it's excluded from regulation altogether. And one of the reasons we know that is because of other sections of 802. 802.17a, for example, defines opium. And it says, as the district court said in her order, she laid this out. It says, but opium does not include the isoquinoline alkaloids of opium. One of the reasons we know that that doesn't mean that the isoquinoline alkaloids of opium are excluded from regulation altogether is that the isoquinoline alkaloids of opium include morphine, codeine, and thebaine. So sometimes excluding something from one definition in 802 just means we're not dealing with that here. The other thing that's notable about the precursor provisions, and Judge Ide, you looked like you wanted to say something.
I so want to say something. I really wish you would just start with your affirmative statutory interpretation. If you could help me understand how you would read the statute from the beginning.
Absolutely. So the CSA is broad. It proscribes and prescribes regulations to multiple types of conduct. So there's conduct involving controlled substances themselves, there's conduct involving paraphernalia, and there's conduct involving precursors. And so in the precursor statutes, there are two lists. One list, which is general items, equipment, material, products, chemicals that may be used to manufacture a controlled substance. and another of which is specific. 3-neck round bottom flasks, tabulating machines, gelatin capsules. That list, that's the second list that I read, but appears first in the statutes, is specific items whose connection to manufacturing controlled substance is obvious. So you don't need the qualifier which may be used to produce a controlled substance, because a gelatin capsule has obvious relevance to the packaging part of manufacturing. And by the way, gelatin capsules inclusion in the list is one indication that manufacture is not just limited to taking one chemical and a second chemical and producing a third chemical, which is chemical synthesis. That's one of the definitions of manufacture, but it's clearly not the only one that Congress had in mind. So when you've got...
The statute defines manufacture.
Absolutely.
Yeah.
And so that makes this case distinguishable from cases like the Abu El Hawa, which I'm certain I'm pronouncing wrong, but the case that talked about the word facilitate in 843B, where that statute, that term was not otherwise defined in the Controlled Substances Act. So the court was trying to divine the ordinary meaning of that term and then saying, well, we don't necessarily need to go to common parlance because we need to look at that term in the context of the statute. We don't need to engage in that sort of analysis here because Congress has done the work for us. And Congress has said, essentially, we don't want to speculate about all the different ways that people could use various substances, chemicals, products to manufacture, prepare, propagate, cultivate controlled substances. So we're going to make it general, and we're going to make the mens rea specific, which is to say more specific than the mens rea that was involved in Casir, which was just knowing that cat is a controlled substance. You've got to know not only that the chemical you're dealing with can be used in a manufacturing process to manufacture a controlled substance.
So you need more than that. Will be used, don't you?
Will be used. Well, so you need may be used, because that's the first part of the definition, right after chemicals, materials, products, or equipment, which may be used to produce a controlled substance. And you need that your customers, or that it will be used. It's passive voice, but that in this case, the customers will be using that product to make a controlled substance. And so that's the balance that Congress has struck in this provision. And it's notable that there's a neighboring provision that has fills a similar role in the Controlled Substances Act, which is 863, which is the drug paraphernalia statute, which is much more specific in terms of the things it lists, in terms of the factors that courts should consider as to whether something is paraphernalia or not. And so it's narrower. And it also shows that Congress knew how to exclude specific things from provisions like the precursor provision when it wanted to, because Section 863 specifically excludes pipes and other smoking devices that are primarily intended for use in smoking tobacco products. So the structure of 843A6 and 843A7 shows that when you've got a chemical product, material, or equipment that is something that you can show may be used to produce a controlled substance or manufacture under the definitions in the Controlled Substances Act, and that this particular defendant knew that that's what it would be used for, very specific mens rea, that is chargeable as a controlled substance precursor offense. And if I may move on to due process.
Is this the first prosecution of poppy seeds as a precursor?
Absolutely not. And we cited some of the examples in the hearing, and so that they're towards the beginning of the hearing transcript with the district court. There was a case out of Iowa, I believe, but it was a couple from Flagstaff who had Carolyn's Dried Flowers was the business, but in reality, the business was a sham just to get poppy seeds in the hands of people who were going to make poppy seed tea. There's also...
These are cases involving just prosecutions. They're not reported opinions, or are they?
No, and I want to be clear. This is, I wish we had a reported opinion on poppy seed tea. We don't, but we have the Carolyn's Dried Flower case out of Flagstaff. And again, we discussed that case at the beginning of the hearing with the district court on the motion to dismiss. There's also the Tew case, which is, again, not a published opinion, but it's from a district court in this circuit that said if you're sending out these specialized water bottles to help people make poppy seed tea by extracting the opium latex from the surface of the poppy seeds, that's manufacturing under the Controlled Substances Act, and so that's possession of precursors. So the question for both statutory interpretation, but in particular due process in this case, because I think the district court was very concerned about the potential lulling into a false sense of security, as Judge Timkovich alluded to at the beginning here. The judge was thinking about this in terms of, would a person just shopping at a grocery store have any inkling that there is some conduct involving poppy seeds that could be illegal? And even if the answer to that question is no, it doesn't preclude this prosecution, because that's not the question under a due process vagueness analysis. The question is, would these defendants be on fair notice that their conduct and the knowledge that they have is proscribed under the Controlled Substances Act? And so they didn't have to specifically know that their conduct was illegal, because ignorance of the law is still no defense. The question is not, did they know specifically that their conduct was illegal? The question is, does the statute provide fair notice? And here it does. In general, statutes preclude conduct, not objects. So the question may well be asked, could a hammer be a dangerous weapon or a deadly weapon? And the answer is, it depends on how it's used. And so the question could come up, could a poppy seed be a drug precursor? And the answer is, depending on how it's used. And based on the very specific knowledge that was alleged in this case, there's no question that the statute can be applied this way and that the statute can constitutionally be applied this way. And if I may, if there are no further questions at this point, I'd like to reserve the remainder of my time.
Sure.
Bless you.
Ms. Yaffe?
Good morning, Your Honors. I'm Leah Yaffe on behalf of my client, Rachel McCarthy, but also the co-appellee, Brandon McCarthy, as we filed the same brief. But for the record, Mr. McCarthy's counsel, Alan Moritzen, is also present today at the counsel table. So I just want to start by talking about what's apparent from the indictment. The government's underlying theory of this case is that the McCarthys have distributed a readily consumable form of opium latex to opium users who they knew were going to ingest it to get high. That's the alleged conduct. And I just want to point into the indictment where they talk about selling to, quote, opiate users, refer to most buyers as, quote, individuals purchasing the product for personal use and consumption, and describe in paragraph 8 that consumers ingest unprocessed poppy seeds to get high, and that, quote, the most common method of ingesting unprocessed poppy seeds coated in opium latex is brewing poppy seed tea. So why do I say this? It's because, in other words, the underlying conduct that's being alleged here is distribution by the McCarthys and possession by the end users. And this is a problem for the government because Congress has explicitly legislated that poppy seeds with opium latex coating are not a controlled substance. What that means is, like every other not controlled substance, even if it has properties that could be dangerous, you can't be charged under the Controlled Substance Act for distributing, and you can't be charged for use or simple possession. So with that statutory exemption not challenged on appeal and clear from the text of the Controlled Substances Act, the government is trying to get at that exact same conduct through a statute, the precursor statute, that's a manufacturing statute. It's intended to stop the process of the creation of a drug in the first place. And it's a poor fit to try to jam what is essentially distribution and possession conduct that perhaps the government thinks should be illegal but isn't, into a manufacturing statute. It just isn't designed for this case, and it's not a good textual fit. And just to kind of illustrate the result of the government's argument here, you have it being legal under the Controlled Substances Act for someone like the McCarthys who knows about the properties of poppy seeds to sell to someone they know is an opium user if that person is intending to eat a couple of cups of poppy seeds raw to feel that opiate effect. Same if they sell to an opiate user who is maybe going to suck on the seeds for a while to try to get some of that latex off and then spit them out. If I put them in my morning smoothie, I've ingested the seed, I'm maybe getting an intoxicating effect from that, but this isn't controlled under the Controlled Substances Act. However, according to the government, if a user prefers to drink the latex via poppy seed tea and has strained out the seed from that water, those users have suddenly manufactured a controlled substance under 841A1 and are subject to the penalties that come along with that. These are the same people that in the indictment, the government has referred to as opium users and individuals purchasing the product for personal use. So just getting to outline sort of the textual hooks that I'm talking about here. The first, I think I've sort of alluded to, and Judge Timkovich, you did as well, which is this statutory exemption for distribution and possession of this not controlled substance covers the exact conduct that we're talking about here. That's why it's inconsistent. Our argument is not more broadly that if you exempt something in one part of a statute, it necessarily exempts it in the other part of the statute. What I'm saying is here, what is specifically exempted is the conduct at issue in this case, and that is why the precursor statute is a backdoor to criminalization of something that Congress has already spoken on. That's textual hook number one. Even if we don't look at the statutory exemption, we then need to look at the text of the precursor statute itself. And there are at least two limiting components of the text of that statute that make it clear it's not intended to cover a particular method of consumption by the end user. So the first is the itemized list of precursor nouns. Whether it's one or two lists, they're together in this statute. And the first four, the more specific nouns here, are a very specialized flask that allows for multiple chemical reactions at one time, what's essentially a pill presser, a tabulating machine, so putting the drug into pill form, an encapsulating machine, which I understand to be putting a drug into capsule form, and then the gelatin capsules themselves. None of those, to me, invoke an end user using a product. It's not common that you would think of a user of a drug as first putting their drug into pill form and then ingesting it. All of them invoke some sort of deliberate process that is more than just getting after an end user, and that's because we're talking about manufacturing.
You're looking at 843A7, right?
6 and 7, the same list of nouns.
So 7 prohibits distributing any equipment, chemical product or material which may be used to manufacture a controlled substance, intending or having reasonable cause to believe that it will be used to manufacture a controlled substance.
Correct, Your Honor.
So why does that not cover selling these seeds to someone whom you know will be using it to make the tea that contains a controlled substance?
I think an assumption in that question is that washing a coating of latex off of a seed is necessarily manufacturing within the context of the Controlled Substances Act, and it certainly is not. Because if it is, then pretty much any minor action that an end user takes to consume a drug, lighting a joint, the government has conceded you wouldn't refer a spoon that you might heat something up in order to ingest it, that wouldn't be something under manufacturing. If just washing off, even if it's a vigorous shaking process, a coating that pre-exists, that the government was ready to charge as a controlled substance in its own right, is manufacturing a controlled substance, then I think there's a real problem with this statute, because it means it's not clear to anyone if you have manufactured something and you're subject to a felony, or if you've maybe possessed something like a joint and lit it, and now you're subject to a misdemeanor simple possession offense. So
could you then address 802.15, which is the definition of manufacturing.
Sure.
And it does say manufacture means the production, et cetera, either directly or indirectly or by extraction from substances of natural origin.
Absolutely.
Can you
So
distinguish that? Yeah.
the government assumes that removing a coating of latex from a poppy seed, which their own indictment says doesn't have any alkaloids in the poppy seed, is extraction under the manufacturing statute. I'm not aware of a case that specifically talks about extraction, but if you look at what extraction means in other contexts of drug manufacturing, for instance, if you think about removing cocaine from a coca leaf, the first process is to extract the coca paste. It's somewhat of an involved process. The district or the DC Circuit has described it as the leaves undergoing an extensive processing before where processors shred the leaves, mash them with a strong alkali like lime, a solvent like kerosene and sulfuric acid. Then you get this light brown paste that then has to go through further manufacturing to be powder cocaine. I'm sorry if the microphone went out. My point being that this assumption that washing something is extraction is, I think, erroneous, both in terms of how we typically see extraction in the drug manufacturing context, but also because this statute and the verbs within it must be interpreted in a way that does not collapse the distinction between a manufacturing and a use.
What about getting gold out of gold ore? You're sluicing it with water. No one would say that's extracting the gold from the rock that you dug up?
I don't have a lot of mining factual background, Your Honor, but I do think even if there's a way to describe, if I say I bought some fruit last night and I washed off the dirt and the pesticides, I've extracted them, I could say that, but we're talking about interpreting an action in the context of the Controlled Substances Act, which specifically delineates between manufacturing and use. And so the definition of manufacturing in the context of this statute has to be interpreted in a way that can't be extended to something that an end user is doing with an end product. I do want to note, though, that I think that there are two distinct, although interrelated, limiting textual components of the precursor statute. So one is the definition of manufacturing, which can't be extended to its broadest possible form, or we're left with a real problem in the Controlled Substances Act. But the second is this list of nouns, once again. So it invokes, when you're talking about a precursor, when we're going to penalize somebody for contributing to a manufacturing process, even if theoretically you could say that because one step of an assembly line is lighting something on fire is manufacturing, we're not going to go after the person who provides a lighter to the person with a joint because we need more of a deliberate production process in order for the statute to apply.
Before you get to that, I was just thinking about, Sudafed, which is a lawful product, and, as a precursor, obviously, but how would you distinguish sort of the Sudafed precursor case versus the poppy seed precursor case?
Because Sudafed, when it is being used to manufacture some other drug, can be a precursor. It's okay that it's a substance. My point here is that poppy seeds with opium latex on them are a readily consumable form of opium latex that Congress has carved out from the Controlled Substance Act and said is legal as an end product.
And so is Sudafed.
And so Sudafed, I'm not quite sure if Sudafed is a listed chemical, but if it is, then it can be prosecuted in that way.
Let's assume it's not.
Yeah, so Sudafed is not going to go in the precursor statute. Sudafed, as used in the process to manufacture methamphetamine, might be a precursor, and so it's somewhat context dependent. But there are any cases that I'm aware of, and certainly not that the government has cited, where the precursor statute has been applied essentially to the use of an end product. Nearly every case at the circuit level that I have seen talks about methamphetamine. I understand the statute isn't limited to methamphetamine, but where it's been used is in these real deliberate production processes. There's not a case where end user, heroin user used a spoon to ultimately ingest the heroin product, and that's been considered manufacturing, or that's been considered distribution of a precursor.
But intent is what's the key here.
Yeah, so let me talk about.
You're selling this product encouraging people to manufacture the opium by extracting it through tea. I know you don't like the word extracting. I didn't mean to foreclose that argument. But they're getting the opium through the tea. That's their clear intent. And the purpose is to give the buyer a means of creating opium for them to get high.
So I want to talk about the intent piece because the government continues to kind of make the dichotomy between knowing that someone's going to use it to get high and knowing that, you know, maybe somebody's going to make a poppy seed muffin. That's actually not the relevant distinction here. The relevant distinction is, do you know that this method of using a drug to get high is okay, and this method of using the drug is not? So it's carved out one particular method of consumption of poppy seeds. The McCarthys could legally, under the statutory exemption for a controlled substance, for it not being a controlled substance, distribute the poppy seed to someone they know is a drug user who's going to eat the poppy seeds raw. They can know all of that and not know that just because the user decides to follow the most common method of ingesting, that now suddenly they're on the hook for precursor penalties, and also that end user is on the hook for a manufacturing penalty. So that's really what the distinction is here, is there enough in the statute for somebody to know that a particular method of use, a particular method of consumption is not okay when everything else is. And I think, going to vagueness quickly in my last minute, if the court is unsure whether the precursor statute could cover this conduct, as applied to this case, there is an affirmatively misleading and part of the statute where you have this statutory exemption saying the distribution of poppy seeds to a drug user for that drug user to get high by eating them is okay. Now we've interpreted a manufacturing statute to say, except when that person drinks the opium via tea. That is an affirmatively misleading statement in a different part of the Controlled Substances Act that both poses a fair notice problem for persons in the McCarthy situation, but also is a separation of powers problem because, as I understand it, the government continues to think this only applies to poppy seeds with a particular amount of opium latex on them. Are they going to charge somebody who tells you how to make poppy seed tea with a processed poppy seed and it's poppy seed tea light? That's not clear from any of the argument that the government has briefed or made today. There's both a separation of powers and a notice problem because of the interaction between the statutory exemption for distribution and use, even in the drug context, and this one method of use to drink the opium from poppy seed tea.
Could I ask? Yeah. Do we have one list here or two lists?
I read it as one list, but I don't think that particular question matters, so I'll just point the court quickly to the Fisher case, the Supreme Court case in 2024. You have subsection C1 and subsection C2. That's two distinct subsections. C2 is a broader otherwise subsection. C1 has specific conduct that constitutes obstruction in that context. So this is the obstruction of an official proceeding statute. Subsection C1 has very specific ways to violate the obstruction statute, which relate to the destruction of documentary evidence. Subsection 2 is saying and other forms of obstruction too. And this was applied to the January 6th conduct, and the Supreme Court said, we're gonna read those two subsections together, even if they're two delineations in the statute, because otherwise you have rendered this four highly particularized verbs and means of violating that statute utterly surplusage. You can't go from, this is obviously about destruction of documentary evidence to and anything else too, including assault. And so, I don't think that the 1 to 2 thing is sort of a misleading point here. Thank you, Your Honors.
So something that Ms. Yaffe just said was that Sudafed, when it's being used to manufacture meth, would be a precursor, and it's conduct specific or context specific. And I hope I'm not misquoting. But that is exactly the same argument that we are making about poppy seeds. Sudafed is not in and of itself a controlled substance. Pseudoephedrine is a listed chemical, but it's not a controlled substance. And then you have cases involving things like lithium, which is not a controlled substance or a listed chemical, but can be used as a precursor. And then the other thing that I heard was that manufacturing under the Controlled Substances Act doesn't connote an end user making things for his or her own personal use. That totally flies in the face of all the manufacturing cocaine base cases that we've got, where all you need to be a manufacturer of cocaine base is a pot, water, cocaine powder, and baking soda. And you can make that for your own personal use. And it also flies in the face of the Wood case from 1995, where this court said, even though you claim that all you were doing was cutting some leaves off of marijuana plants, that's manufacturing under the Controlled Substances Act. Because like Ms. Yaffe said, it's conduct specific, it's context specific. The other thing that I just want to point out is that there's nothing in the indictment or in the record that says you can make a controlled substance by eating poppy seeds raw. The indictment makes very clear, although it says one of the ways to get the opium latex off poppy seeds is by making poppy seed tea. What's being alleged here is that they extracted the opium latex from the surface of the poppy seeds by making poppy seed tea. There's no allegation and there's no reality. If you talk to some of these end users of the poppy seed tea like we have, there's no reality that you can get any sort of a high from eating poppy seeds raw. And by the way, the word extract, which I think Judge Hartz asked about, that just means to take out of. So it comes from the Latin trahere, which means to pull or to draw. So there's nothing fancy about extracting something from a substance of natural origin. So if there's no further questions, we'd ask the court to reverse.
Thank you, counsel. Case is submitted. Counsel are excused. We'll turn to 25-4006, U.S. versus Lansing. Ms. Stengel, whenever you're ready. Do you need a moment?
No, I'm good. Let's
Okay.
do this. I don't,
You look like I caught you off guard, and I didn't want to.
standard for me. May it please the court, Jessica Stengel appearing on behalf of Randy Lansing. District courts are frontline defenders of the integrity and dignity of the criminal justice system. Dignity disappears when perjury is allowed to taint proceedings. We know this from the Supreme Court. Musa Rosh versus United States. Integrity absolutely disappears when the end result takes priority over the processes by which we reach that result. The integrity of the criminal justice system requires that the ends never justify the means. And that's what happened in this case. Mr. Lansing, it was a rush to conviction, and by rush, we need to look at the numerous instances of delay caused by his ineffective assistance of counsel at the trial level. And the district court sanctioned trial counsel acting as a mere friend of the court rather than an active advocate, which is what is required by Chronic and the Sixth Amendment. Mr. Lansing finally received competent counsel after he was convicted at trial. Through the diligent work of competent counsel, newly discovered evidence was presented to the district court. The district court was having absolutely none of it. And Mr. Lansing is asking this court to reverse the district court's refusal to even consider his motion for a new trial, to allow the district court's decision to stand as it is, would be to transform Rule 33 from a substantive due process-based procedure into simply a matter of incanting magic words. And I think this court would be in a difficult position were it to sanction what happened below, given how it decided and what it considered in United States versus Meacham, which was a 2009 case, where after being convicted at trial, the defendant decided, this was super bad, I'm gonna get a whole bunch of people to say that they lied at trial. The district court kind of had an inkling, but held a multi-day evidentiary hearing. And after that hearing, the district court, listening to all of the evidence, all of the testimony, concluded that, in fact, the evidence was newly discovered. Even the failure to learn of the evidence was not due to a lack of diligence. The evidence was not merely impeaching, and the evidence that this defendant presented was in fact material to the principal issues involved, and in Meacham, it was a drug distribution case.
Let's look at those elements here.
Yes.
One is whether it's newly discovered, because what she recanted were things that the defendant would have personal knowledge of, what she had been doing with him that day and what she had done in his presence. And I'll go to one other element before you need to respond. And the second issue is what difference these recantations made, because she didn't recant the substantive allegations about what the defendant did in the murder. These were, she had been drinking before. Not matters that went to her testimony about the defendant's murder of the victim. So if you'd respond to those, please.
I'm going to work backwards, and if I forget something, please remind me. So I would say that it absolutely goes to the substance of what happened. Ms. Benally's admissions of perjury absolutely are material as to who did what at the creek. In other words, she might have been at the room where it happened, but she was not honest or forthcoming about what her role in the decedent's death was. And I think that's evident by her.
Well, wait. You're not saying that you get a new trial because you get impeachment evidence, are you?
No, this is not impeachment evidence by a long shot. This is, Ms. Benally perjured herself, and it's material because it goes to what happened. And a 3-page affidavit should have been enough for the district court to say, time out, let's put her on the stand to understand the substance and extent of her lies. And the effect it had on trial is substantive. If we look at the government's closing arguments, both in its initial closing argument and in its rebuttal, the prosecutor repeatedly referred the jury to Ms. Benally's testimony. Take away her testimony, and what we're left is a child who had been sleeping and drinking, and is a child and is undoubtedly traumatized by whatever may have happened that night, and then 2 medical examiners who cannot tell you how the injuries resulted. Ms. Benally's testimony was critical, and the district court fundamentally erred in simply concluding, without any semblance of process, that it wasn't so.
Well, I'm not sure about your distinction between substantive testimony and impeachment. When you say then take away her testimony totally because she lied, but she didn't change the specific testimony about misconduct. On the issues that she lied about, like having been drinking, did the prosecutor in closing, either opening close or rebuttal close, point out, and this was a sober woman who knew what was going on?
Yes, Your Honor.
He did.
There were 2 eyewitnesses that the government needed to directly connect Mr. Lansing with what happened to Ms. Clark, the decedent. And again, one of them is a kid who had been drinking and couldn't tell you if it was light or dark at 11 a.m. The other is Ms. Benally, who absolutely had a personal interest in lying to protect herself. And what the district court, regardless of what you think about Ms. Benally or what I think about Ms. Benally, the district court had an obligation to do more than rush to sentencing. Without honoring the processes and procedures in place, there can be no faith in the integrity of the conviction. And the district court jammed through it simply to get to sentencing and move on.
You know,
Well, maybe-
I'm going to
Go ahead, no, go ahead.
I'm here.
Well, you know, the defendant knew, you know, the facts as, you know, since he was there, and, you know, is evidence newly discovered if the defendant all along knew the contrary facts that came out later through the affidavit?
First of all, I'm going to say it's a presumption of what Mr. Lansing knew or didn't know, given the amount of alcohol and the intensity of what was happening. Notwithstanding that, for it to be newly discovered, it cannot have existed before trial. We presume competent counsel, and it is based on that that the courts have limited the notion of newly discovered evidence to something that a defendant should not or could not have known. That absolutely depends on the existence of effective, even if not wholly competent counsel, and that was 100% missing from Mr. Lansing's trial case. To hold him—
The problem here is the defendant might have known it, but his trial counsel did not.
Absolutely.
And the trial counsel did not know because
Trial counsel decided—
asked, or it wasn't volunteered by.
Trial counsel, even if Mr. Lansing had volunteered anything, that would have been not a virtual, a real impossibility, because trial counsel didn't visit, didn't call, didn't communicate with his client. Trial counsel was, in the words of this court, a mere friend of the court rather than an active advocate. Trial counsel fell down.
How do we, I mean, sounds like a pretty good ineffective assistance of counsel claim.
Sure.
How do we factor into, you know, the motion for new trial?
Sure,
I mean,
absolutely.
I see the relevance, but is it really an element of what we should consider for your argument?
It is, Your Honor, because for two reasons, and let's hope I remember both of them. One, this court absolutely has addressed ineffective assistance of counsel on direct appeal when the record is so pellucidly obvious. This is pretty much it. We don't need to go through every minutia of mistakes that trial counsel made. We have enough on its face. Second of all, in addition to the motion for new trial, one of the grounds Mr. Lansing raised was ineffective assistance of counsel. And he specifically asked for a hearing on that. And under this court's precedent, when a defendant makes a colorable claim of ineffective assistance of counsel, a district court is required to hold a hearing. And the district court absolutely did not hold that hearing. Judge Ide, I think you had a question?
Actually, I was going to ask the same question.
Okay.
If you already know all the facts and you don't tell them to your attorney, I think the concern is if we say, well, you have to tell them to your attorney, that creates an incentive for the defendant not to tell his attorney. And then after conviction on appeal, go, can you help me with that?
I will try.
Okay.
In the first instance, I will say that this case seems to be a unicorn. It is not that, it's relatively rare that we get such an egregious case of ineffective assistance of counsel that whatever a defendant may or may not know remains well hidden due to the absence of effective counsel. And the case law and fundamental fairness, I would say, are in your favor, where the defendant cannot withhold information with the hopes of playing, quote, the evidentiary trump card after the fact. I will say this court was quite gracious to the defendant and the district court in United States versus Meacham. It's a 2009 case. This is the one where the defendant, after his trial, full-on manufactured evidence that he claimed was newly discovered. And the district court, in honoring the process, in honoring the integrity of the conviction, said, okay, let's have a hearing. And he went through the 5 steps that this court has, the 5 criteria. and at the end of the day said, I'll even give you newly discovered, wink, we all know it's not. Your evidence is incredible. But there was a hearing, there was a process, there was an opportunity to test it, and that simply didn't happen in this case. And if there are no further questions, I will reserve them.
Just quickly, looking at my notes, did the district court reject the ineffective assistance claim on the merits below?
No, the district court refused to consider the ineffective assistance claim below.
Okay, and you didn't appeal that?
We did not.
Okay.
Thank you. I'll reserve the remainder of my time.
Mr. Palmer?
May it please the court, Joseph Palmer for the government. I'd like to just briefly begin by explaining why we think the issue of ineffective assistance of counsel isn't properly before the court, and then talk about the merits of the newly discovered evidence issue, which we think is the sole question presented here. Now, the district judge denied the motion as to ineffective assistance of counsel on two grounds. One of them was timeliness, and one of them is on the merits. And the district court's decision at page 38 of the volume 6 of the supplemental record, the district says, I'm on to the merits now and not just time. And then the district judge explained that it was denying the ineffective assistance of counsel ground for the Rule 33 motion because the claim wasn't apparent to the judge on the record. The judge says, I didn't see ineffective assistance of counsel at trial. These ineffective assistance of counsel claims require record development, and so I'm deferring those claims to a collateral proceeding under Section 2255, and it denied the Rule 33 motion without prejudice to raising the ineffective assistance of counsel claims in a Section 2255 proceeding. Now, there's no question that it's within the district court's discretion to do that. Section 2255 is the standard procedural vehicle for ineffective assistance of counsel claims. And more importantly, the defendant's briefing doesn't challenge the district court's decision to do that. And so because there's no challenge in front of you, there's no argument that the district court erred or abused its discretion in deferring the ineffective assistance of counsel claims for the Section 2255 proceeding. Those claims aren't before the court. And they shouldn't be imported into the claim that is before the court, which is whether the district court abused its discretion in denying, in finding that the 5-element test for newly discovered evidence wasn't met here. Now, if I could just turn to that issue. But first, it's important to recognize that this court's cases say that new trial motions based on newly discovered evidence aren't favorably regarded and should be granted only with caution. And the court gives broad deference to a district court's determination that the new evidence wouldn't have affected the outcome. Because the court recognizes that the judge who had a front row seat at the trial is in the best position to make that call. And in this case, the district judge who heard and saw the witnesses firsthand made the call that the evidence in Shannon Benally's affidavit wouldn't have affected the outcome. And this court should defer to that fact-bound judgment. The defendant's motion for new trial based on newly discovered evidence couldn't satisfy any of the 5-element test for relief under Rule 33 based on newly discovered evidence. First, the evidence wasn't newly discovered because it was known to the defendant before the trial. He knew whether he had a sexual relationship with Shannon Benally. He knew whether she had drunk alcohol. He knew whether there had been any physical contact between the two women. And evidence that is...
What about the argument that he was too impaired to know these facts?
Well, first of all, that wouldn't go to the relationship side of things. And, you know, I'm not sure that that claim was raised below, and I just don't think that generally the intoxication or potential intoxication of the defendant as applied to transactions where he was there is really an excuse for the requirement that Generally, if the allegedly newly discovered evidence is conversations or events at which the defendant was present, it's reasonable for the district judge to find that this isn't newly discovered evidence because he knew about it before the trial. The defendant also can't carry his burden to show that his counsel acted diligently in discovering this information before the trial. He argues affirmatively that his counsel wasn't diligent. And so that might help him in the 2255 proceeding for ineffective assistance of counsel, but it forecloses his ability to establish that second element of the test for newly discovered evidence. The third and fourth prongs. In this case, the district court reasonably found that the evidence was, at most, merely impeaching and wasn't material to the principal issues at trial. The material aspect of Ms. Benally's testimony was that she saw Mr. Lansing brutally attack the victim at the creek. In her affidavit, she doesn't recant, and she doesn't contradict, and she doesn't undermine that principal aspect of her testimony. And her affidavit also couldn't help Mr. Lansing establish his new theory that it was Ms. Benally who committed the murder. He claims that it might help him establish a motive. But the jury was aware that Mr. Lansing was in a romantic relationship with both of these women. And the evidence about physical contact was even less material. Of course there was physical contact between two women who spent the whole day together in a small SUV crammed with 3 other people. And the last element of the test, Mr. Lansing must show that he would probably be acquitted based on this new evidence, and the district court reasonably found that he couldn't make that showing. Because the evidence that it was Ms. Benally who committed the murder is essentially non-existent, and the evidence that it was Mr. Lansing was strong. And that evidence includes not only Ms. Benally's unrecanted testimony that she saw Mr. Lansing attack the victim, but it also includes, of course, the testimony of the victim's daughter, who described in detail how it was Mr. Lansing who beat her mother to death and drowned her in the creek. Now, he's attempted to wave away that testimony because she was young and because he forced her to drink half a can of beer and because—
How old was she?
She was 10 years old at the time of the incident and 12 years old when she testified. And that is old enough to know the difference between whether it was Mr. Lansing who killed her mother or Ms. Benally. And her testimony, as for sleeping, her testimony is clear and detailed about that she was awake when she saw the crucial events that she testified about. She said that she woke up when Mr. Lansing pulled her mother from the car. She was awake when she saw him punching her mother, kicking her mother, beating her mother with a bat, beating her mother with a rock. She was awake when she begged him to stop hurting her mother, and he threatened her that he would hurt her too if she tried to intervene. She was awake when she saw him drag her mother by the hair into the river and continue beating her with the rock as she lay helpless in the water. She was awake when he told her to lie and tell the authorities that her mother had died accidentally. And she was awake when he took her back to the scene the next day to help recover the evidence. And if this weren't sufficient, Lansing's own conduct in attempting to cover up the crime confirmed that it was he and not Ms. Benally who committed the murder. It was Mr. Lansing and not Ms. Benally who brought in the body. And it was Mr. Lansing and not Ms. Benally who's heard on a 911 call telling the victim's daughter not to say anything. It was Mr. Lansing and not Ms. Benally who told everyone the obvious lie that the victim had died accidentally and that he had done his best to save her. It was Mr. Lansing and not Ms. Benally who went back to the scene the next day to retrieve the evidence. It was Mr. Lansing and not Ms. Benally who cleaned his car. Your Honor, the bottom line is that the district judge who heard these witnesses and saw the trial found that this evidence wasn't sufficient to establish a likelihood of acquittal. And this court, Mr. Lansing has given no reason for this court to second-guess that judgment. If there are no further questions, Your Honor.
Thank you, Mr. Palmer. Ms. Stengel, you have just under 3 minutes.
Just a few points I'd like to make. Broad deference to the district court doesn't mean blind deference. What the district court did, despite the hyperbole from the government, nobody is denying that this was a terrible attack and a brutal murder. What is fundamentally at issue is the integrity of the conviction. Can we trust it? And we cannot. And what the district court did, without a hearing and based on its own inferences and interpretation of the evidence, said it's not newly discovered, it's not material, it's merely impeaching, it's due diligence, whatever, we're done. It simply repeated the words as though chanting a spell, and that can never stand when a person's liberty is at stake.
When you say there was no hearing, it was done on briefing, is that what you're saying?
It was done on briefing, and there was a hearing on the briefing. The district court at no point was interested in hearing from Ms. Spinelli and her highly generalized admissions of lies.
And the motion for new trial requested an evidentiary hearing at which you would testify?
In the alternative, it did request that, sort of saying, what district court? We would like one. And the district court said...
And did it indicate what they expected to elicit from her at a hearing, at an evidentiary hearing? So that the judge could know, well, there's something more to this than because it was the defense that got her affidavit. So the defense would know if there was something more that could have been put in the affidavit or whatever? Does that argue against an evidentiary hearing?
No, it doesn't, Your Honor. There's no requirement in the rule or in the local rules or even from this court's published case law that says if you're going to ask for a motion for a new trial, not only do you need to produce something, your filings need to be incredibly detailed as to what further you intend to elicit if there were to be an evidentiary hearing. That's just simply not a requirement, Your Honor.
I don't think the district court could assume that because you hadn't put anything further in the affidavit that there really wasn't anything material to be gained by having an evidentiary hearing.
We risk the fundamental principles of justice when we allow district court assumptions to stand in the place of factual findings. So no, I don't think that's ever acceptable. And I see my time has run out, so I will submit the case, and thank you.
Thank you, counsel. Case is submitted. Counsel are excused, and we'll, you ready to go ahead?
Yeah.
You okay to go ahead? And counsel come forward. We're ready to hear 24-6166. Fuston, I'll be told what the correct pronunciation is, versus Quick. I've never seen this. It's exactly 9:30.
Good morning. May it please the court, my name is Callie Heller, and I represent the appellant, Mr. Ronnie Fuston. I'd like to reserve about 3 minutes of my time for rebuttal. Thank you. Your Honors, Mr. Fuston's capital trial and sentencing were unconstitutional in two different ways. First, the jury wasn't instructed on second-degree murder, although under Beck v. Alabama, it should have been. And second, Mr. Fuston never should have proceeded to a capital trial at all, as he is intellectually disabled. The OCCA unreasonably applied the clearly established federal law to deny that Mr. Fuston was entitled to even an Atkins hearing. We ask that you reverse the district court's decision denying relief on these grounds. I'll speak first to Proposition 1, which is the denial of Mr. Fuston's due process rights under Beck v. Alabama. Mr. Fuston's trial included multiple pieces of evidence connecting him to the crime, and his attorneys didn't present any witnesses. His jury faced the exact dichotomy that Beck highlights: evidence of guilt of a serious and violent offense, but doubt with respect to an element that would justify a capital conviction, but no third option. Mr. Fuston's trial also included evidence of an act imminently dangerous to another person regardless of human life and evincing a depraved mind, but without premeditated design to effect death. The shooting came on the heels of multiple days of fighting between friends of Mr. Fuston and the victim's niece on the phone, on social media, and in person, with the latter including acts of vandalism and a gun fired into the crowd. The state's star witness testified that he and Mr. Fuston received a phone call in Enid, Oklahoma about the fighting that had been going on, traveled to Oklahoma City, and then the group that at that point included Mr. Fuston went to the victim's niece's house for, quote, another fight. And the state's crime scene reconstruction evidence showed that the shooting occurred almost simultaneously with the front door being kicked in. There was no evidence that it was known that anyone would be directly inside and in the bullet's path. And despite Appellee's arguments to the contrary, all of that evidence can be considered by this court in analyzing the OCCA's opinion under the EDPA.
Well, when you say we analyze it under EDPA, under what standard?
Under D1 or D2.
Okay, so we are deferential. You agree with that?
Absolutely.
Okay. Go ahead.
On the other hand, Mr. Fuston does not need to prove that there was insufficient evidence to convict him of first-degree murder. As this court has said, focusing on the strength or presence of the first-degree murder evidence would deny as a lesser-included offense instruction precisely where it is most important, where the evidence would support a conviction of first-degree murder, but would also support a conviction under the lesser-included offense. The OCCA nonetheless made the evidence supporting first-degree murder the focus of its inquiry, as it has done repeatedly.
Well, but it did state the correct standard several times, did it not?
Yes, it did. It did. But that nonetheless does not suffice to make its opinion a reasonable application of Beck, similarly to this court's opinion in
Okay,
Ritchie.
so but it did apply, we can assume it applied Beck, but just didn't apply it correctly. It invoked the proper standard. It didn't apply that standard.
Correct.
So that's your argument, okay.
It recited the standard correctly, but then applied it unreasonably. In one of its earlier reversals on this issue, this court explained that the distinct questions under Beck are the sufficiency of the evidence of the greater offense is distinct from Beck, which asks whether the evidence might allow a jury to acquit on the greater and convict on the lesser. The OCCA here collapsed these inquiries, holding that the evidence clearly supports a finding that when appellant fired at the decedent, he did so with the intent to kill. Therefore, the evidence would not permit a rational jury to find the appellant guilty of second-degree murder. In other words, because the first-degree evidence supported a finding of intent, therefore no second-degree instruction was warranted.
Well, that would be the wrong standard. That would be applying the wrong standard. And there is one sentence that suggests that, but there are other sentences that state the rule is there may be sufficient evidence for first-degree murder, but no reasonable jury would convict for second-degree murder under these facts. And isn't that what we have to review? Was that an unreasonable decision to say that on these facts, no jury would have convicted under second-degree murder? I want to make sure we have the right standard of review. Do you agree that that's the correct standard of review?
Yes.
Okay.
Yes, Your Honor. And so the OCCA did set out the correct standard, standard for reviewing the evidence, but they made this statement, which brought the opinion in line with several of the opinions where this court found that the OCCA was not entitled to deference, in Williams, in Phillips, in Taylor, where this court made some variation of finding that the OCCA did not explain why the evidence didn't support second degree, except that it did support first. And the OCCA again explicitly said the evidence supported first degree, therefore the jury could not have found second, sandwiched in between, reciting all of the ways that the evidence would have supported first degree. The OCCA did take a bit of a different step than it had in some of these prior cases by saying a review of the evidence, a review of the record shows that there is no evidence that would have supported a second-degree murder instruction,
But in light of the substance of its opinion and the conclusion it makes, as this court stated, the EDPA inquiry focuses in Grant v. Royal, the overall substance of its opinion was clearly focusing on first-degree evidence, just as it has.
I thought it was saying that the evidence here of intent is such that no reasonable jury could find that he didn't intend to kill. Now, there are two steps in the murders, as I understand it. The evidence apparently shows that they broke in the door and just started firing. But then he saw the victim move and fired 2 shots after that. And I read the OCCA opinion to say that given the second shooting, there can be no reasonable person could determine that the murder was not with intent to kill that person.
So the state's crime scene reconstruction evidence, we don't believe can be read to show a second shooting. So the statement that...
Okay.
Right, the statement that Mr. Butler, the state's star witness, made was that Mr. Fuston, after the shooting, said, I fired multiple times because I saw a movement, I saw the victim getting up or reaching for something. So is it possible that that can show intent? I don't think it's impossible, but as this court found in Phillips and in Hogan, we can still have plausible alternative inferences, and that's not intended to rule out providing the jury what's in their purview to weigh the evidence and decide which verdict best fits it, as long as that low standard of some evidence is presented. So a crime where someone kicks the door open and simultaneously, as the state's evidence showed, shots were fired across the threshold, some of which missed entirely and went into the fireplace. This is an act that could also comport with, like in Taylor, shooting because you saw movement, and that doesn't necessarily have to mean intent to kill. It could mean intent to harm, intent to disable what you, in the heat of the moment, perceive as a threat. So there are alternative inferences to that, and so in a case like that, that means you cannot only have a first-degree instruction.
But we're not reviewing that de novo. Our standard is, what you're saying is it was unreasonable for the OCCA to hold that the evidence, which you're challenging here, of intent was so strong that no reasonable juror could have convicted just on second degree. The standard of review is so important in these issues, so I want to make sure that I'm stating what our job is in this case.
I agree, and I think that's absolutely correct, Your Honor. And I think that is that's exactly in accordance with what the OCCA said, and that is unreasonable, either under D1, which is right in line with the way this court ruled in Ritchie, where this court said that it was an unreasonable application of Beck to find that the evidence was insufficient to raise a reasonable doubt as to intent, or it could also fall under a reliance on an unreasonable determination of fact under D2. In Boyd, for example, was a D2 Beck case in this court, and there the evidence of intent where a gun was placed directly to, I think, either the head or the chest of a police officer, and the defendant's evidence for a second-degree instruction was that he blacked out at the time, and the OCCA said there's no evidence presented that would support a second-degree instruction, and that was not unreasonable under D2, but because this is such a mixed question of fact and law and looks at the evidence presented, we would contend that not only overcomes EDPA deference because of an unreasonable application of Beck and or an unreasonable determination of facts, but also is an entitlement to Beck relief under de novo review after the EDPA is overcome.
And as I'm understanding what you're saying, the key to your argument about it being unreasonable inference is that the OCCA must have decided that the evidence that he shot at the moving person was weak enough that a jury might have, or could reasonably have rejected that testimony. Is that the essence of what your argument is here?
I think that's right, Your Honor, and I think the reason we have to infer that is because, like in Williams, we don't know why the OCCA found that the evidence could not give rise to a second-degree murder
Oh,
instruction.
I thought it was because, you know, I thought the OCCA was relying on the evidence that the defendant, after bursting into the building, saw someone move, and it was no longer just random shooting. He was trying to kill the person who moved by shooting 2 more times. I thought that was its reasoning. And what I understand you to be saying is that reasoning is based too much on questionable evidence.
I think that was in the larger context of an adjudication that proceeded solely on examining and reciting and relying on the first-degree evidence. So the OCCA found that the group met to formulate a plot to kill Brittany Dillard, which was not that was not the only reasonable view of the evidence, and we would argue that's actually contrary to the evidence, that they went to her house and then Mr. Fuston kicked open the door, also was not what the evidence showed, and that he then, yes, fired multiple times because after the fact, as Mr. Butler testified, he said he saw the victim move.
Kind of a variation of that. Let's say that he kicks in the door, kicks in the door, and the first shot was intended to scare whoever was in the room or in the house. But then he saw the person and fired 3 shots that entered the body. Even though the first shot could support maybe a depraved murder instruction, can that be dissipated by the subsequent acts that were, intended to shoot directly at the victim?
I think
Or do you get second degree under my facts either way?
I think it can be, and I think again that those facts are not that different than the facts in Taylor. That was also multiple shots. And I think what's very relevant there, also just related to Taylor, is that was not uncontroverted. So the defendant said he shot multiple times because he saw movement, and the state argued the path of the shots as shown by the forensic evidence contradict that. And still it was found that that should have been submitted to the jury to make that weighing determination, as this court said, I believe in Taylor as well. That's the purview of the jury. It's not for courts under Beck to decide which best fits the evidence or which is stronger. Unless there are further questions on Beck, I'll move on to our second issue. Our second issue is the state court's violation of Mr. Fuston's rights under the 8th Amendment. The Supreme Court has said again and again over decades that those with intellectual disabilities are exempt from capital punishment and that states must use clinical guidelines to ensure that everyone entitled to that protection receives it. After Andrew v. White, it's more clear than ever that these governing legal principles have the force of clearly established federal law. In this case, that means that applying a strict statutory cutoff in a way that necessarily violates the clinical guidelines unreasonably applies the clearly established federal law. And it violates clinical guidelines to deny even an Atkins hearing to someone with a historical, quote, mild mental retardation diagnosis, multiple qualifying scores under prong 1, a lifelong history of adaptive deficits under prong 2, yet a single score above the statutory cutoff. We know that from the guidelines, and we know that from clinical practice, because none of the experts involved in this case made any kind of decision based solely on the 81 outlying score. It's true that Hall applied the clinical guidelines to a case where the underlying decision revolved around a cutoff that was lower than that used here, and where the standard error of measurement was also at issue. But crucially, Hall specified that it was doing so because the clinical definitions of intellectual disability were a fundamental premise of Atkins. And barely a page of Hall goes by without reference to or reliance on those clinical guidelines, medical standards, and scientific definitions. Hall made clear that where a state ignores those standards, it risks executing a person who suffers from intellectual disability. That risk is all the more intolerable for someone like Mr. Fuston, who is denied even the chance to present his evidence. The idea...
Was it a misapplication of clearly established law? And it seems like there's a lot of question about what clearly established means in these circumstances. A couple weeks ago, the Supreme Court had oral argument on a different case, but a similar issue. And I mean, how can we say it's clearly established here when the Supreme Court's still out there granting cert on related issues?
Yes, so I think a critical distinction, and I think, are you referring to Smith v. Ham? But a critical distinction there is that this case involves simply passing the threshold without which you are precluded from even presenting your evidence. And so that is in line with the situation in Hall v. Florida. Smith v. Ham revolves around how courts then must make or may make their weighing determinations in making the Atkins decision and how they weigh the evidence. But in cases like Hall and in Mr. Fuston's case, the defendants are not allowed to even present their evidence. So when it comes to a case like that, however Smith v. Hall comes down, we don't think that that is going to change what the CEFL says in that.
So we can still find it was clearly established here regardless of what the Supreme Court does in the pending case?
I believe so, Your Honor.
Well, the defendant can put on evidence without some threshold showing. Do you agree to that?
Yes.
The Oklahoma statute sets a threshold that you may well challenge because it just requires one test score over 175. But in the opinion of the Supreme Court in this case, the Oklahoma Court of Appeals, Criminal Court of Appeals, it addresses the 5 tests administered and really challenges the validity of 4 of them. One was in full scale. One, everyone agrees, was not taken properly. And the other 2 were after the defendant knew that if he did poorly enough, he couldn't be executed. And are we stuck with what the statute says, or can we look to what the OCCA actually did and decide that in this circumstance, it wasn't a denial of due process to say that the defendant hadn't passed the threshold for putting on evidence?
I think that if we were here after an Atkins trial or hearing and arguing that the fact finder did not properly weigh various findings, in a battle of the experts, that would be a very different question. But I think here, the OCCA making findings like that, that is not why Mr. Fuston was disentitled to a hearing. So the 81 score is what disentitled him to a hearing. So if the OCCA, if he didn't have what was found to be disqualified.
Yeah, that was disqualified under the statute.
Correct.
What if the OCCA goes further than the statute, is more lenient toward defendants than the statute is? Does that make a difference?
I don't know that it would make a difference because the OCCA is not the fact finder. So the OCCA they weren't making a determination of whether he is intellectually disabled. So even several of those pieces of evidence, that's refuted. Several of those scores were after the developmental period and after he was charged with capital murder, but that's not supposed to be relevant under clinical guidelines. And even aside from that, he was administered several malingering tests, including by the state's expert, and was found to not be malingering and making good efforts. So, the OCCA kind of cherry-picking certain facts that have questionable relevance. Again, I think if those were findings made by the fact finder after a hearing, then the argument could be whether that was proper under Atkins or, a denial of due process or the standard for making an Atkins determination, and was that met. But here, those questionable facts, I don't think that they entitled Mr. Fuston to any more protection in the statute. So I think the way that one of Mr. Fuston's prosecutors put it before the trial is very illuminating here. He said that the idea that there's some score that an intellectually disabled person could not attain, and that what that score is subject to debate among professionals, underscores this violation, because all of the professionals involved in this case either found that Mr. Fuston meets diagnostic criteria despite the single outlying score, or had to move on to consider the adaptive functioning evidence, including the state's expert, despite the single outlying score, which also illustrates, again, why all of this evidence should have been before the fact finder to make the same determinations and weighing of evidence and facts. Whatever the IQ threshold above which a professional could not diagnose or even consider intellectual disability, in this case, it has demonstrably not been met. The OCCA applied the strict cutoff anyway and found that this obeyed Supreme Court law due to an unreasonably narrow definition of what that law entails. The Eighth Amendment prohibits Mr. Fuston's execution, and Supreme Court law entitles him, at the very least, to a hearing where he is able to prove that.
Oklahoma's statute, I guess, is one of a kind, isn't it?
Yes, Your Honor.
A lot of states have variations on it, but it's the only one that has, like, if you're above once, we're done.
Yes.
And his high score was at a younger, was that the first test he'd ever taken? And then, like, he was a teenager, perhaps? How old was he?
12.
And you're not saying, does the Constitution prohibit a bright line cutoff?
I don't think we have to necessarily argue that it does in every circumstance. So we don't need to say that this statute is per se unconstitutional, needs to be thrown away in order for Mr. Fuston to be entitled to some form of relief here.
Yeah. Would your argument be the same if there was one score below 75 and one score above?
I don't know that it would, because our argument is so reliant on clinical guidelines and the clinicians who have been engaged in this case. So I think where you vary those kinds of factors and the IQ scores at issue, you might not have a case where the experts either found that the defendant was intellectually disabled, or where even the state's expert proceeded to prong two to consider the other evidence. If you have IQ scores that are so clearly disqualifying or really lean towards that, you might have all experts saying, we don't need to consider anything besides prong one. He doesn't have sub-average intelligence, and therefore there's no reason for the rest of the Atkins determination.
But the statutory scheme doesn't require, if I'm understanding it correctly, doesn't require any evidence from clinicians. It's kind of a, the state would say, well, we don't need to look at these examinations. All we need to know is the score. And I spot your argument that here we have, experts that have looked at this person and have these diagnoses, but I think the state might say that's irrelevant. And I think, but you might say, well, he had one score of 74 and another one of 100. You'd be probably making a different argument.
That might be a very different case. And I think, if the state does say that's irrelevant, I think that only underscores what the problem is. Clinical guidelines say that that can't be irrelevant. You can't, like as cited in Hall and relied on in Hall, clinicians and their guidelines say that you can't simply say an IQ is final, conclusive, standalone evidence of, or evidence against intellectual disability. You need to rely on clinical judgment, and you need to be able to look at the weighty and substantive, which was the language used in Hall, evidence that those in the medical community would consider probative even with an IQ score above 70.
Thank you.
Counsel,
Thank you.
you've
I'll reserve
reserved some time.
Thank you.
Good morning, Your Honors. May it please the court. My name is Michael Trapasso, and I am here on behalf of the warden, Christy Quick, who is the respondent in this case. I'll begin first with petitioner's Beck claim. In ground one, he claims that it was a 14th Amendment violation for the court not to instruct on second-degree murder. But petitioner fails to meet his burden under both D1 and D2 for multiple reasons. Primarily, as this court noted in questioning petitioner's counsel, the OCA applied the correct standard here. Petitioner even conceded that. This case is different from Williams, Phillips, Taylor, Hogan, because here the OCA did not purely rely on the evidence supporting first-degree murder. The OCA concluded that there was no evidence supporting a second-degree murder instruction, and thus there was no evidence from which a rational jury could find petitioner guilty of second-degree murder. Specifically, this is what the court wrote. A review of the record showed petitioner did not present any evidence, nor did the state's case provide any, showing he engaged in imminently dangerous conduct and extreme disregard for human life. Based on that conclusion, the court said that a reasonable jury would not have the evidence would not have permitted a rational jury to find him guilty of second-degree murder.
Well, let me ask you some questions about that. If the evidence were clearly that all that happened was he threw open the door and shot randomly, and there were no later two shots at someone who he saw move, would that support a second-degree murder conviction?
If the evidence supported purely shooting recklessly,
Bursting open the door and shooting, yeah.
potentially, Your Honor, but that is not the situation presented here.
Well, that's what I want to ask about, because what opposing counsel was suggesting is the evidence that went beyond that was questionable evidence.
It was not, Your Honor.
Okay.
Specifically, the evidence on which, well, let's talk about what the OCA based its decision on first. And this is unrebutted by facts from the record on petitioner's side. The OCA based its decision primarily, on the finding that, I'm sorry, let me get to my right page here. I'm sorry, just one moment. Specifically, the court based its finding on the fact that petitioner had been recruited by his fellow gang members to drive from to find and kill Ms. Dillard, and that he drove from Enid to Oklahoma City, where they met together to formulate a plan to achieve that end, and that when he kicked in the door, he had the intent to kill anyone in the room. Let's talk about the evidence. Even accepting primarily that, let's say, petitioner kicked in the door or was shooting as the door was being kicked in. That actually supports a finding of premeditation, Your Honors, because we have to consider the evidence as a whole. The other evidence was not suspect. We have the crime scene reconstructionist testifying that the room, and State's Exhibit 35 shows the room was roughly from the door to the back wall was about 20 feet, give or take. We know petitioner was seated on the closest end of the, Mr. Rhodes was seated on the end of the couch closest to the door. And all of the bullets were directed north at where Mr. Rhodes was seated. This is not a situation where he merely sprayed the room or was just shooting recklessly. Petitioner went into that home and fired 5 shots at Mr. Rhodes. And we know that because he said said he saw Mr. Rhodes move, which shows he had.
And the
he aimed.
physical evidence supports that? Is that
Yes,
right?
Your Honor, because all of the bullets were fired from petitioner's gun. The bullet defects were all directed north in the direction of where Mr. Rhodes was seated. The projectile, the fireplace, and the chair where other bullet defects were found were all north in the area of where Mr. Rhodes was seated. And moreover, Your Honors,
You can take it.
the OCA's decision was supported by the evidence such that fair-minded jurists could agree with that decision. Petitioner must show that there was evidence from which a rational jury could convict him of second-degree murder and acquit him of first-degree murder. He has not met that burden. I'd point this court to your decision in Grant. There, the court concluded that none of the facts on which the petitioner relied clearly and convincingly unseats the OCA's finding that all of the evidence surrounding the killing suggested a degree of premeditation, and that the court could not say, given the facts in this record, a rational jury could have found the petitioner acted without any premeditated design to kill the victim. And to the extent the OCA discussed in its opinion a premeditated design to kill, that is based on the definition of second-degree depraved mind murder. Specifically, second-degree depraved mind murder under Oklahoma law occurs when perpetrated by an act eminently dangerous to another person and evincing a depraved mind regardless of human life, although without any premeditated design to effect the death of any particular individual. To the extent the OCA is discussing premeditated design in its opinion, that is not discussing the sufficiency of the evidence for first-degree murder. That is saying petitioner did not meet the last element of second-degree depraved mind murder, which is that there was no premeditated design. And again, Your Honors, the uncontroverted evidence on which the OCA based its decision was that petitioner drove from Enid to Oklahoma City at the request of fellow gang members, and he met with them to formulate a plan to kill Ms. Dillard and anyone else in the home. Petitioner has not rebutted that with facts from the record, and that is binding on this court. Moreover, to the extent petitioner, if I heard correctly in his argument, discussed that the evidence did not support a meeting between petitioner and his fellow gang members, that is conclusively refuted by the record. We know that they went to, it was either Ms. Jordan or Ms. Pennon's apartment to discuss a plan of what they were going to do. So that's, sorry.
Couldn't a jury have disbelieved that? In other words, discounted the credibility of those planning witnesses. And if that is true, doesn't that get the defendant here closer towards a lack of evidence of premeditation?
No, Your Honor, because you have to consider all of the evidence as a whole. You can't just take one fact specifically to the exclusion of all others. Here, all of the evidence, as I've discussed, the direction of the bullet defects, the physical evidence corroborates, taken as a whole, with the evidence on which the OCA based its decision, shows a premeditated intent to kill here, Your Honor.
But that's really not what I'm saying. That I mean,
Okay.
the witness statements, it's credibility and all that, and they say what they say. But the question, the Beck question is, could a reasonable jury discount the credibility of these witnesses in such a way that would get a possibility of a second-degree conviction?
I do not believe they could, Your Honor. Based on the evidence taken as a whole, I do not believe they could disbelieve that. Especially when you consider the evidence showing that the state presented cell phone logs showing petitioner's conversations with the government phone used by Ms. Jordan and Ms. Pennon collectively, showed not just leading up to the murder, but the day of the murder, there were calls. I couldn't even count the number of phone calls between the two cell phones. So we know petitioner was discussing this extensively with Ms. Jordan and Ms. Pennon and the other gang members. And then we know as he came down to Oklahoma City, they were still discussing it, and they met to discuss it, and they continued Even though they drove through South Oklahoma City looking for someone to rob, the phone calls leading up to the murder show and the cell location data show that they were driving all in the same direction towards the Rhodes home. So all of the evidence taken as a whole, I do not believe a rational jury would not have been able to find petitioner guilty of second-degree murder in this case.
Did you say a government phone?
Yes, Your Honor. So there was Ms. Jordan and Ms. Pennon had a friend who would go and purchase a large number of government phones. You could go to a stand and just, if you were collecting welfare or other government benefits, you could sign up and just get a free cell phone.
Okay.
And that's the phone that they had their friend.
I was thinking someone was acting undercover or something.
Oh, no, I apologize, Your Honor.
No, that's.
Yeah, sorry.
Okay.
But yeah, basically, if you were collecting public benefits, you could get a government phone. And that's what they use to formulate their plans for this. The only argument which petitioner relied at the OCA regards the timing of the shots, and that is the only argument on which he can rely here, Your Honors. To the extent he points to Mr. Butler's testimony that he guessed they were going back to the Rhodes home for another fight, that is not properly before the court.
Is that me?
Government phone.
Sorry about that.
Do you know where that's coming from? Is it me?
It's coming from my iPad.
Oh, huh, okay.
Didn't know it was phone.
I didn't either.
Sorry to interrupt your train.
No.
I'll take the
Big
$50
generous with the
fine.
time, yeah.
And further, it's not even a fact on which petitioner is relying here when he says the timing of the shots. It's an inference from a singular piece of evidence to the exclusion of all of the other evidence presented at trial, Your Honors. And this court has repeatedly concluded that speculation is insufficient to meet your burden of showing entitlement to a lesser included offense instruction in Darks, which the court, even reviewing de novo, there the court concluded that any inference of provocation was, quote, mere speculation insufficient to establish the provocation needed to support heat of passion manslaughter. And then in Robideau, the court, there the petitioner pointed to evidence in the record of prior altercations between him and the victim, arguing that the murder could have resulted unintentionally from another such altercation. And this court rejected that claim, first because it concluded it did not square with the evidence, and because speculation about what might or might not have occurred, quote, did not constitute sufficient evidence to require a lesser included offense instruction under Beck. The overwhelming weight of the evidence at trial showed that petitioner had the intent to kill Ms. Dillard and anyone else in the home. Again, as I've discussed, the bullet defects, the physical evidence, the diagrams showing how close Mr. Rhodes was to the door, petitioner's statement to Mr. Butler that he shot multiple times because he saw Mr. Rhodes move, and it was supported by the crime scene reconstructionist that Mr. Rhodes was indeed moving when he was shot. That was also presented. And we also, again, yes, and moving briefly to D2, Your Honors, petitioner also fails to meet his burden here to the extent he claims that this was a mixed question of law or fact, the OCA's decision. This court has concluded that even mixed questions of law and fact do not come within the auspices of D2, and that's under Wood. Regardless, he has not shown all fair and minded jurists could agree that the OCA's determination was incorrect. He still has not rebutted the finding of the OCA that he intended to kill at the home. The timing of the shots we submit actually supports that he intended to kill. Also, I would point the courts, I apologize for not bringing this up earlier. There's a picture in State's Exhibit 36 of a bullet defect in the door, and it shows, looking to that, you can see it's not as if the door was closed when the bullet passed through. The door was clearly open, and the bullet clipped the side of it in the direction of where Mr. Rhodes was seated. Moreover, the OCA did not ignore the evidence as petitioner claims. It merely concluded there was no evidence from which a rational jury can find that petitioner did not act with a premeditated intent to kill. And if there are no further questions, I will move to the Atkins claim.
Let me start that off with some questions, because reading the transcript, I didn't listen, but reading the transcript of the recent Supreme Court argument, everyone seemed to treat and accept that Oklahoma was an outlier, which in itself is problematic, but it didn't get any defenders in the argument. And we'll find out what the ultimate decision is in that case. We don't know. You can't always tell by what, as you've learned with this court, you can't always tell from what happens at oral argument. Mm-hmm. But put that together with the Andrew case, which I must say I was surprised by the Supreme Court's, I think, reconstruction of what clearly established Supreme Court authority is. How do you get over those two humps?
For starters, Your Honor, to the extent petitioner relies on the transcripts of oral argument or briefing in the Ham v. Smith case, he did not rely on those arguments at the OCA. While those specific statements were not available to him, he could have mustered those same arguments himself. So that is not properly before the court. And to the extent, I'm sorry, Your Honor, what was your second question? I apologize. Oh, Andrew. Andrew, yes, sorry. Andrew does not apply here, Your Honors, because we are not arguing there's no clearly established law. The question here is whether the OCA unreasonably applied the general principles of Atkins and its progeny, Your Honors. Andrew was specifically concerned with the discussion of clearly established law. To the extent we are arguing that the Supreme Court, petitioner's argument misconstrues the Supreme Court arguments. Specifically, the Supreme Court has never held specifically that states cannot use an IQ cutoff score. The Supreme Court has held that states cannot use an IQ cutoff score that does not account for the standard error of measurement. That was the issue in Hall. The Florida Supreme Court's decision was reversed in Hall because it took the petitioner's 71 IQ score as conclusive, but did not factor in what that score range would be with the standard error of measurement. That's why Hall reversed the Florida Supreme Court's decision. Further, to the extent petitioner argues that the clinical standards mandate consideration beyond just one IQ score, the Supreme Court has never squarely established what standards apply, how to apply them, what to do in cases of multiple IQ scores like we have here. And as such, it was not an unreasonable application of the clearly established law for the OCA to say, as it did in its opinion, these decisions do not, the Supreme Court's decisions do not mandate a different outcome.
Well, that's the problem. They haven't clearly established that. In Andrew, they hadn't said specifically how to review evidence of sexual misconduct by the defendant. What they said was clearly established was it has to be fair. And that's not a lot more specific than what they've said in the case law regarding intellectual disability and the death penalty.
Your Honor,
so that's where I'm hung up.
I apologize, Your Honor.
No, it's not your fault.
It's the Supreme Court,
yeah.
To be honest, has not provided extensive guidance on what to do in these situations. But to the extent they have not, it is not an unreasonable application of the clearly established law for a state court to decline to extend a specific rule that has not been squarely established by the Supreme Court. And the Supreme Court has said that repeatedly, particularly in Knowles v. Merzance.
That's exactly what Andrew disrupts. I mean, it was, unreasonable application of law under the due process clause, and, that before Andrew required some specificity, and they've amped up the level of generality in that case, and you amp it up into this Adkins arena. There's, a lot of cases that are suddenly at risk that you thought might not be proper Adkins claims before Andrew.
Your Honor, respectfully, I would push back a little bit on that interpretation of Andrew. Andrew was focused specifically on the clearly established law, not unreasonable application. Atkins established the general principle that states cannot execute someone who is intellectually disabled. It left to the states, however, how best to determine who meets that definition. Hall mandates consideration of the standard error of measurement, and to the extent Hall, Brumfield, and Moore require consideration of clinical standards, but not all clinical standards, as the court said in Moore, it was not, the more general the rule, Your Honors, the more leeway state courts have in reaching outcomes and case-by-case determinations. This is a general rule where the Supreme Court has not squarely established what to do, what clinical standards apply, how to apply them, or what to do in situations of multiple IQ scores. And for that reason...
Our error in Andrew 1 was thinking that because there are no cases involving this type of evidence, there's nothing to give us sufficient guidance to really review it. So we said we're not going to review that issue. And the Supreme Court said no. Now it went back to us to see was unreasonable application, but there was nothing specific in Supreme Court decisions that gave us any guidance except our sense of fairness. And that's not that different from the guidance the Supreme Court is giving in the intellectual disability arena.
Your Honor, I would point the court to the decision in Moore specifically. While the court noted that clinical guidelines should not be wholly disregarded, it also said that states need not adhere to everything stated in the latest medical journal. So I would think that distinguishes this a bit more from Andrew. Further, Your Honor, to the extent petitioner asserts that the Supreme Court's decisions mandate consideration beyond a singular, IQ score in every case, that is foreclosed by the language in Hall. Specifically at page 723, the court wrote, "The court agrees with the medical experts that when a defendant's IQ test score falls within the test's acknowledged and inherent margin of error, then he should be allowed to present further evidence of intellectual disability." And in Brumfield, that was reaffirmed, where the court again reversed a state court's decision. I apologize for not stating this at the beginning. It is also important to note the procedural posture of the Supreme Court's cases. Hall and Moore were each direct review cases. The issue of EDPA and the deference required under EDPA were not applicable in those cases. And to the extent the court reversed in Brumfield, which was the only habeas case, it was because the state court again failed to account for the standard error of measurement, what score that would yield. And notably, the court explained in Brumfield that if there was evidence of a higher score than 75, that could have rendered the state court's decision reasonable. So I think that's very important to consider as well.
You have a record where the score above 75 looks like an outlier, and maybe that's this case a bit, but there are multiple scores below the threshold, one above taken when the defendant was young, every other test, even before the specter of a murder trial was there, were low. And you have, some clinical evidence that's presented. It seems like, the thrust of the case law is, well, the defendant gets an evidentiary hearing under Atkins, he might lose that, but, he still gets a neutral adjudication of the disability question. And here, it's, you don't get that if there's one good score.
Your Honor, I would just again say the Supreme Court has not clearly established what to do in situations with multiple IQ scores, and it is not an unreasonable application of the clearly established law to refuse to extend a specific rule that has not been squarely established by the Supreme Court.
Would your argument be different if we didn't have that deference?
I'm not entirely sure. I don't believe so, Your Honor, but this court does have EDPA deference. I apologize. But the Supreme Court, again, has never mandated that state courts cannot use a singular IQ score to deny Atkins relief. And additionally, I would also like to touch on this court's prior decisions on this issue. Specifically, while we maintain that Smith, Tryon, and Postel are still applicable here despite petitioner's abandonment of his Flynn effect claim, in Smith particularly, this court stated, while yes, there is a footnote noting that petitioner was primarily relying on the Flynn effect, here, Your Honors, in Smith, the court still concluded that the OCA's decision finding its statute constitutional was not an unreasonable, was not contrary to or an unreasonable application of the clearly established law, particularly Hall, because it excludes, the statute excludes only those whose SIM-adjusted IQ scores fall outside the generally accepted range for intellectual disability. So even if, and the court in Smith specifically said that Hall focused exclusively on the standard error of measurement. And then in Postel and Tryon, the court appeared to indicate, or appeared to believe that the issue of the constitutionality of Oklahoma's statute had already been addressed. In Postel particularly, the court noted that it had previously addressed the constitutionality of the statute in Smith. And then in Tryon, the court again concluded, the court concluded neither trial nor appellate counsel were ineffective because the petitioner had an 81 IQ score like the petitioner here, and that precluded any ID claim under state law, which we would maintain, and we would maintain that those cases are still applicable here, Your Honors. If I could just reiterate again, Your Honors, petitioner's argument, to the extent he claims that the Supreme Court has mandated consideration beyond just one IQ score, that has not been squarely established by the U.S. Supreme Court, and it was not an unreasonable application of those cases for the OCA to decline to extend that specific rule that had not been clearly established. Unless there are any further questions, Your Honors, we ask that this court affirm the denial of habeas relief as to both petitioner's Beck claim and his Atkins claim. Thank you.
You don't think we should wait on the Atkins claim to see what the Supreme Court says?
No, Your Honor, because we would maintain that that would be Teague barred. It would have to be all fair-minded jurists, all reasonable jurists reading the Supreme Court's decisions would have to be able to conclude that the Supreme Court mandated consideration beyond just the singular IQ score. And as we've discussed, that is not the case. And so we would maintain that whatever happens in Ham v. Smith, that would not affect the outcome of this case, Your Honors.
Thank you.
Thank you, Your Honors.
I'll briefly make a few points about Beck before moving on to Atkins. I would first note that the language that Appellant used today and throughout her brief about the evidence needing to be considered as a whole sounds a lot like a weighing determination to me. That's not a standard that has been drawn from any of this court's jurisprudence. The case in which this court used the as a whole language was in Mitchell, which was a case where one of the cases where this court did not defer to the OCCA because the OCCA did not review the evidence as a whole and excluded a piece of evidence in saying that there was no entitlement to a second-degree murder instruction, which this court did end up agreeing with that determination, but along the way said that there was no deference due to the OCCA not viewing all of the evidence. I would second briefly note, we don't dispute that Mr. Fuston met up with the other participants in Oklahoma City and many times throughout the shooting occurring. That does not mean that they were formulating a plan to kill, and there's no evidence of that. Mr. Butler's evidence to the contrary, his testimony was that they were going to the victim's niece's house for another fight. There's nothing that makes that evidence speculation, and as we briefly discussed in our 28J response, that is briefly before the court, and nothing in Andrew v. Tinsley or anywhere else makes that not fairly presented to the state courts below.
The trial court sitting there, defense says, I want this instruction. It seems like the trial judge who sat through the trial is going to evaluate the evidence as a whole necessarily to answer the Beck question. And decide whether the Oklahoma, element of not done with the intention of taking the life has, there's evidence that would support a jury conclusion of that.
He was supposed to, Your Honor, that's right. And I think some of this court's cases like Turrentine and Taylor, that was part of the equation, that there was a decision for a second-degree instruction, but it was the instruction itself.
I'm just saying that the trial judge is going to be looking at the evidence as a whole necessarily.
Yes, and here we contend that he violated Mr. Fuston's due process rights in that decision. And finally, briefly, I'll just speak to Grant, which was brought up. The evidence there was a disputed evidence that there was a mental infirmity that prevented the intent from being formed, and the evidence, the defense's expert did not actually present evidence of that, so that was rejected. And that's similar to Bryson, which the state in Williams said was an example of a case showing that sometimes the evidence of intent is so strong that there is no need for a second-degree instruction. And this court in Williams distinguished that and said in Bryson included evidence of plotting for a month. And similarly here, our case is distinguished. I'll move on to a brief rebuttal of some points in the Atkins claim. We would contend that the Supreme Court has provided extensive guidance on how to adjudicate Atkins claims. Just because these have been in the forms of more general clinical guidelines does not change what the result needs to be. We saw Mr. Hall, who had a high score of 80, receive relief back in state court. We saw Mr. Moore receive relief from the Supreme Court with a high score of 78. In Oklahoma, they would have been executed. Not adhering to everything in the latest medical guide does not mean states are free to disregard clinical guidelines. Thank you.
Thank you, counsel. You got a lot in your time.
Tried.
Well, that's helpful to us. Case is submitted, counsel are excused, and court is adjourned, right? Okay, recess subjected to call.